Hello. How are you? Thank you for joining. If you are joining from Facebook, I can't see you in the chatmosphere, but I do come over to Facebook occasionally and I'll check in with you. If you're on Twitch, I want to thank you for joining from Twitch. And those in the chatmosphere, I'd like to welcome the first one here, and that would be 420 Wild Dragon. Hello. Blunts up. How are you? Okay, listen, I'm going to jump right into reading this 13th Amendment. Okay, so when the playback happens, it'll just, okay, people won't be as upset with me. Not that they are, but I'm going to come into the chatmosphere and check on you, okay? So tonight I'm going to be reading the 13th Amendment to the United States Constitution. And there's a reason for this. I want to read the 14th Amendment as well. Maybe tomorrow, if you'd like to have a Saturday outside, me reading the Constitutional Amendment 14, just let me know. Drop it in the chatmosphere if you want to hang out on Saturday, okay? I promise to be on my best behavior, okay? I will have no coffee and no absinthe, okay? All right, so listen, let me go ahead and begin. I had some images as well. So I'm going to set that up so that you can see, because you know what? I want to give you a feel for 1865. I know we talk about the 1800s a lot. There are so many pieces to this puzzle that are coming together. And I'm really grateful for so many different people who are helping me to understand some things. And these things are really important, especially to identity and to, let's see, what else? Identity is really one of those things that we have talked about in the other live streams, but let me go ahead and I have it set up and I'll share my screen. Thank you for joining on a Friday. That is so nice. Friday. Okay. Yeah, this is it here. Okay. So I'll just be playing these images for you. I just selected a few. Alrighty. Okay, let me go ahead and just start that. It has no volume, but I'll just be reading. Okay. Thank you for your patience. I'll read an overview of. So we'll start out with a definition. So we'll make this really scholarly. The 13th Amendment to the Constitution is also known as abolition of slavery, and this is 1865. Passed by Congress on January 31st, 1865, and ratified on December 6, 1865. The 13th Amendment abolished slavery in the United States. In 1863, President Lincoln issued the Emancipation Proclamation, declaring all persons held as slaves within any state or designated part of a state, the people whereof shall then be in rebellion against the United States, shall be then thenceforward and forever free. Nonetheless, the Emancipation Proclamation did not end slavery in the nation, since it only applied to the areas of the Confederacy currently in a state of rebellion, and not even to the loyal border states that remained in the Union. Lincoln recognized that the Emancipation Proclamation would have to be followed by a constitutional amendment in order to guarantee the abolishment of slavery. The 13th Amendment was passed at the end of the Civil War, before the Southern states had been restored to the Union, and should have easily passed in Congress. However, though the Senate passed it in April 1864, the House initially did not. At that point, Lincoln took an active role to ensure passage through Congress. He initiated that passage of the 13th Amendment be added to the Republican Party platform for the upcoming 1864 presidential election. His efforts met with success when the House passed the bill in January 1864 with a vote of 119 to 56. On February 1st, 1865, President Abraham Lincoln approved the joint resolution of Congress submitting the proposed amendment to the states' legislatures. The necessary number of states, 3/4, ratified it by December 6, 1865. The 13th Amendment to the United States Constitution provides that neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to its jurisdiction. With the adoption of the 13th Amendment, the United States found a final constitutional solution to the issue of slavery. The 13th Amendment, along with the 14th and 15th, is one of the trio of Civil War amendments that greatly expanded the civil rights of Americans. Okay, so that was just a brief it was an academic from a college website. So I don't want to, I'm not giving my opinion about anything at this time. I just want to read. And if you see something, say something, okay? I want us to hear, because I'm listening with different ears right now. Okay, now I will begin to read the actual amendment. Are you ready? 13th Amendment to the U.S. Constitution, January 31st, 1865. Slavery and involuntary servitude, 13th Amendment. Sections 1 and 2. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Congress shall have power to enforce this article by appropriate legislation. Abolition of slavery, origin and purpose. On January 1st, 1863, President Lincoln issued the Emancipation Proclamation declaring, based on his war powers, that within named states and parts of states in rebellion against the United States, all persons held as slaves within said designated states and parts of states are, and henceforward shall be free. The proclamation did not allude to slaves held in the loyal states, and moreover, there were questions about the proclamation's validity. Not only was there doubt concerning the president's power to issue his order at all, but also there was a general conviction that its effect would not last beyond the restoration of the seceded states to the Union. Because the power of Congress was similarly deemed not to run to legislative extirpation of the peculiar institution, a constitutional amendment was then sought. After first failing to muster a 2/3 vote in the House of Representatives, the amendment was forwarded to the states on February 1st, 1865, and ratified by the following December 18th. In selecting the text of the amendment, Congress reproduced the historic words of the Ordinance of 1787 for the government of the Northwest Territory and gave them unrestricted application within the United States. By its adoption, Congress intended, said Senator Trumbull, one of its sponsors, to take this question of emancipation entirely away from the politics of the country. We relieve Congress of sectional strifes. An early Supreme Court decision rejecting a contention that the amendment reached servitudes on property as it did on persons, observed in dicta that the word servitude is of larger meaning than slavery, and the obvious purpose was to forbid all shades of conditions of African slavery. Although the court was initially in doubt whether persons other than African Americans could share in the protection afforded by the amendment, it did continue to say that although Negro slavery alone was in the mind of the Congress, which proposed the 13th article, it forbids any other kind of slavery now or hereafter. If Mexican peonage or the Chinese coolie labor system shall develop slavery of the Mexican or Chinese race within our territory, this amendment may safely be trusted to make it void. This amendment is undoubtedly self-executing without any ancillary legislation. So far as its terms are applicable to any existing state of circumstances, by its own unaided force and effect, it abolished slavery and established universal freedom. These words of the Court of 1883 have generally been non-controversial and have evoked little disagreement in the intervening years. The force and effect of the amendment itself has been evoked only a few times by the court to strike down state legislation which it considered to have reintroduced servitude of persons, and the court has not used Section 1 of the amendment against private parties. In 1968, however, the court overturned almost century-old precedent and held that Congress may regulate private activity in exercise of its Section 2 power to enforce Section 1 of the amendment. Certain early cases suggested broad congressional powers, But the civil rights cases of 1883 began a process culminating in Hodges versus United States that substantially curtailed these powers. In the former decision, the court held unconstitutional an 1875 law guaranteeing equality of access to public accommodations. Referring to the 13th Amendment, the court conceded that legislation may be necessary and proper to meet all of the various cases and circumstances to be affected by it, and to prescribe power modes of redress for its violation in letter or spirit. And such legislation may be primary and direct in its character, for the amendment is not a mere prohibition of state laws establishing or upholding slavery, but an absolute declaration that slavery or involuntary servitude shall not exist in any part of the United States. Appropriate legislation under the amendment, the court continued, could go beyond nullifying state laws establishing or upholding slavery. Because the amendment has a reflex character also, establishing and decreeing universal civil and political freedom throughout the United States, and thereby empowering Congress to pass all laws necessary and proper for abolishing all badges and incidents of slavery in the United States. These badges and incidents are perceived by the court. However, were those that Congress in its 1866 legislation had sought to secure all citizens of every race and color, and without regard to previous servitude, those fundamental rights which are the essence of civil freedom, namely the right to make and enforce contracts, to sue, be parties, give evidence, and to inherit, purchase, lease, sell, and convey property. As is enjoyed by white citizens. But the court could not see that the refusal of accommodations at an inn or a place of public amusement without any sanction or support from any state law could inflict upon such person any manner of servitude or form of slavery, as those terms were commonly understood. It would be running the slavery argument into the ground to make it apply to every act of discrimination which a person may see fit to make. Then in Hodges versus the United States, the court set aside the convictions of 3 men for conspiring to drive several African Americans from their employment in a lumber mill. The 13th Amendment operated to abolish and to authorize Congress to legislate to enforce abolition of conditions of enforced compulsory service of one to another, and no attempt to analogize a private impairment of freedom due to a disability of slavery would suffice to give the federal government jurisdiction over what was constitutionally a matter of state remedial law. I'm still here, just checking. How are you all doing? All right. Hodges was overruled by the court in a far-reaching decision that concluded that the 1866 congressional enactment, far from simply conferring on all persons the capacity to buy and sell property, also prohibited private denials of the right through refusals to deal, and that this statute was fully supportable by the 13th Amendment. Surely Congress has the power under the 13th Amendment rationally to determine what are the badges and the incidents of slavery, and the authority to translate that determination into effective legislation. Nor can we say that the determination Congress has made is an irrational one, just as the Black Codes enacted after the Civil War to restrict the free exercise of those rights were substitutes for the slave system. So the exclusion of Negroes from white communities became a substitute for the Black Codes. And when racial discrimination herdsmen into ghettos and makes their ability to buy property turn on the color of their skin, then it too is a relic of slavery. And the very least, the freedom that Congress is empowered to secure under the 13th Amendment includes the freedom to buy whatever a white man can buy, to the right to live wherever a white man can live. If Congress cannot say that being a free man means at least this much, then the 13th Amendment made a promise the nation cannot keep. 1 minute. Let me get my place. How's it going? How's it going? All right. You know what? I am wondering, am I actually reading the you guys don't be mad at me, because I wonder if am I on an educational site? Is this like commentary, right? Okay, Karen, I made you moderator. Did you get the message? Okay, hold it everyone. I'm getting back to my place. Because okay. Bear with me. Just speak among yourselves. Black codes can. Okay. All right. Here, I left off here. The 13th Amendment then could provide the constitutional support for the various congressional enactments against private racial discrimination that Congress had previously based on the Commerce Clause. Because the 1866 Act contains none of the limitations written into the modern laws, it has a vastly extensive application. Peonage, notwithstanding its early acknowledgement in the slaughterhouse cases that peonage was comprehended within the slavery and involuntary servitude proscribed by the 13th Amendment. The court has had frequent occasion to determine whether state legislation or the conduct of individuals has contributed to reestablishment of that prohibited status. Defined as a condition of enforced servitude by which the servitor is compelled to labor against his will in liquidation of some debt or obligation, either real or pretended, peonage was found to have been unconstitutionally sanctioned by an Alabama statute directed at defaulting sharecroppers, which imposed a criminal liability and subjected to imprisonment farm workers or tenants who abandoned their employment, breached their contracts, and exercised their legal right to enter into employment of a similar nature with another person. The clear purpose of such a statute was declared to be the coercion of payment by means of criminal proceedings of a purely civil liability arising from breach of contract. Several years later, in Bailey versus Alabama, the court voided another Alabama statute that made the refusal without just cause to perform the labor called for in a written contract of employment or to refund the money or pay for the property advanced thereunder. Prima facie, evidence of an intent to defraud, and punishable as a criminal offense, and that was enforced subject to a local rule of evidence that prevented the accused for the purpose of rebutting the statutory presumption from testifying as to his uncommunicated motives, purpose, or intention. Because a state may not compel one man to labor for another in payment of a debt by punishing him as a criminal if he does not perform the service or pay the debt. The court refused to permit it to accomplish the same result indirectly by creating a statutory presumption which, upon proof of no other fact, exposes him to conviction. In 1914, the United States versus Reynolds, a third Alabama enactment, was condemned as conducive to peonage through the permission it accorded to persons fined upon conviction for a misdemeanor to confess judgment with a surety in the amount of the fine and cost, and then to agree with said surety in consideration of the latter's payment of the confessed judgment, to reimburse him by working for him upon terms approved by the court, which the court pointed out might prove more onerous than if the convict had been sentenced to imprisonment at hard labor in the first place. Fulfillment of such a contract with the surety was viewed as being virtually coerced by the constant fear it induced of rearrest, a new prosecution, and a new fine for breach of contract, which new penalty the convicted person might undertake to liquidate in a similar manner, attended by similar consequences. Bailey versus Alabama was followed in Taylor versus Georgia and Pollock versus Williams, in which statutes of Georgia and Florida, not materially different from the one voided in Bailey, were held unconstitutional. Although the Georgia statute prohibited the defendant from testifying under oath, it did not prevent him from entering an unsworn denial both of the contract and of the receipt of any cash advancement thereunder, a factor that the court emphasized was no more controlling than the customary rule of evidence in Bailey. In the Florida case, notwithstanding the fact that the defendant pleaded guilty and accordingly obviated the necessity of applying the prima facie presumption provision, the court reached an identical result, chiefly on the ground that the presumption provision, despite its non-application, had a coercive effect in producing the plea of guilty. Pursuant to its Section 2 enforcement powers, Congress enacted a statute by which it abolished peonage and prohibited anyone from holding, arresting, or returning, or causing or aiding in the arresting or returning of a person to peonage. The court looked to the meaning of the 13th Amendment in interpreting two enforcement statutes, one prohibiting conspiracy to interfere with exercise or enjoyment of constitutional rights, the other prohibiting the holding of a person in a condition of involuntary servitude. For purposes of prosecution under these authorities, the court held the term involuntary servitude necessarily means a condition of servitude in which the victim is forced to work for the defendant by the use or threat of physical restraint or physical injury, or by the use of threat of coercion through law or the legal process. Situations in which the amendment is inapplicable. The 13th Amendment has been held inapplicable in a wide range of situations. Thus, under a rubric of services which have from time immemorial been treated as exceptional, the court held that contracts of seamen involving to a certain extent the surrender of personal liberty may be enforced without regard to the amendment. Similarly, enforced of those duties that individuals owe the government, such as services in the army, militia, on the jury, etc., is not covered. A state law requiring every able-bodied man within its jurisdiction to labor for a reasonable time on public roads near his residence without direct compensation was sustained. A 13th Amendment challenge to conscription for military service was summarily rejected. A state law making it a misdemeanor for a leaseor or his agent or janitor intentionally to fail to furnish such water, heat, light, elevator, telephone, or other services as may be required by the terms of the lease and necessary to the proper and customary use of the building was held not to create an involuntary servitude. A federal statute making it unlawful to coerce, compel, or constrain a communications licensee to employ persons in excess of the number of the employees needed to conduct his business was held not to implicate the amendment. Injunctions and cease and desist orders in labor disputes requiring return to work do not violate the amendment. Okay, I read all of it, everyone. All right, how's it going here? Oh my gosh, John is here. Welcome, John. Hey, how are you? Thanks for joining and hanging out. Okay, help me, someone. Did I read the actual amendment, or was this? I had a lot of tabs open, but I just read 4 pages of what I think was the amendment. Is that the amendment? Chime in, everybody. Is Big Pontiac here? Where's Big Pontiac? Oh my goodness. Hey there. Greetings, Big Pontiac. Greetings, Jim. Look, Adam came to class tonight. What is the difference between America and the United States of America? That is such a good question, Adam. You are paying attention. Does anybody have the answer? What is the difference between America and the United States of America? Who knows that answer? And I'm going to come in and say, hey. Okay, I am going to double check to see if was that the actual one? Somebody tell me. Let's see. Helen, thank you for joining. You all. Thank you so much. Look at that. Okay. Does anybody have their Constitution out? Hi, Aaron. Thank you. You're not late to class. Thank you. Let's see. T. Witten. Persons regarding paper, people in contracts. Get it yet? Thank you for that, T. Witten. Exactly. If you see something, say something. The 13th and 14th Amendments made us employees of the corporation. Yes, indeed. All right. Well, I'm telling you. Let's see. T. Witten says courts are banks for the corporation commerce. That's why it always involves money. You like these photos, Linda? I'm glad you like them. I wanted to get a few images together. And yeah, Destiny Rose, so much legalese. Yes. Rawhide. Hello. Looked like a bunch of hemp growers. Oh, I bet. Yeah, I bet they were. Yes. Okay. Dana's here. I had no idea there was so much in the 13th Amendment. I know, right, Dana? Now, somebody double check me, because when I looked it up, that's what I just read, okay? It does seem like it was mixed with, I guess I didn't know what to expect, okay, everyone? This is my first time reading this amendment all the way through. I don't think I read anything but maybe a title when I was going through I used to always keep a pocket Constitution, and I probably just looked at the title, and skimmed through it. Has anybody read the 13th Amendment in here? Let's see. You like the pictures too? All right. An educational piece. Yeah, was that an educational piece or was it the actual amendment? Because I don't have my little book right now. Okay, I will. Yeah, hey, Cher, the actual republic and the corporation. Okay, there you go. Okay, you said, Dana says, my pocket constitution is more like a Cliff Notes version. Okay. Hey, Teresita, you're here. What a contrast in buildings. Yes, definitely. You sent a link to me? Oh, good. Wait a minute. John sent a link to me. You guys may have to hang out a little bit longer. Okay, wait, John. I don't see it yet. Wait, you guys may have to hang out a little bit longer. I may have to read another. Do you want to hear more bedtime story? Constitutional bedtime story? Class / whatever? Because I could redo this video and read another round, okay? Section 1, Dana says. Section 1, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place. Yes, the cold hard truth. How are you? You're here for it, Adam? Okay, good. Let me just I'm double checking, okay? Because John is going to keep me on point here. Okay, John, I'm looking to see, did it come through? Did you send it to my email, John? I'm checking. Wait, John, hold it. Let me look. Bear with me, everyone. I'm going to look in my email to see what John has sent me. John, I don't see anything. Not yet, John. What's going on? Cher said the amendments made it legal to enslave you by imposing crazy sentences that don't fit the crimes, thereby making corporate profitability from criminalizing little things. Exactly. Exactamundo. Okay, so I'm going to probably just play this back, okay? Let's see. Because I want to make sure I was reading. Hey, Philo. Philo Bobcat, good evening. Thank you for joining. Yes, indeed. Hey, Mickey, you're saying I was just typing that. Yes, you said it, Jen. Section 2 is Congress shall have the power to enforce this article by appropriate legislation. Thank you. Thank you very much. Okay, John, you said yes. Let me double check again. What's going on, John? I'm not seeing anything. Okay, look, this is what I'm going to do. Hang on for anybody who wants to hang a little bit more, because I will do this. I'm going to do this again, another search. I would have rather have read it from my pocket. Okay, I'm double check myself. You would think it's right there. I looked on .gov. Congress. Okay. So is it just, wait a minute. Under .gov. Okay, 13th Amendment, Section 1. I'll just reread it, everyone. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2, Congress shall have power to enforce this article by appropriate legislation. So is that it, everyone? I just read an expanded kind of, what was that? That was like a college type of thing, scholarly. So, Jen, I posted what my pocket one said and on the website. Okay, so it's just that short. It was really just those two sections. Let me know, because I'm looking on the .gov site. I didn't know this was such a short read for the 13th Amendment. 2 sections. But what I read was, when I read this from a state historical website. And okay, so it was a teaching. All right, so that was a teaching module that I read you all. Yeah, it seemed to be a narrative. That's what I was thinking, because did you notice it went from calling Negroes, African Americans, and then it went into, it was, okay, I should have known. Okay, I'm sorry. I read somebody else's opinion. That was an opinion piece off of a University of a State Historical Society of Iowa. How did I wind up there? Okay, so you just got a little bit of, not just a little bit, but a lot of opinion. It is night class after all. It's night class. I went a little bit overboard there. Okay, sorry you all. Okay, Sean says, "Wow. Okay, that makes a lot more sense now." I was putting you to sleep, right? Yes, 2 sections. Oh my goodness, right, Mickey? Just 2 sections, and I went there. So 1865. This vibe right here. This vibe. What are you getting? What are you picking up on? The images and the issues of the day in this particular time. What are you saying, Adam? All states and schools teach different things. True. Yeah. Okay. Thank you, Lisa. I knew it was like, wait a minute. Okay. A little too much. Hey there, Diesel D's. Hi. Thank you for joining. T. Witten says the original 13th Amendment said no one with titles of nobility can serve in government, i.e., esquires, British bar members, until the first bankruptcy of America. What year was the first bankruptcy of America? It really is short, somebody said. Cher said it really is pretty short. Who knew that? We could have been memorizing that all this time, right? I didn't know it was that short. You know how you just make things harder for yourself? I tend to do that. So I just go, Tina, welcome, Tina. Hey, everyone, I'm just getting on. Oh, I'm glad you're here. Hey, Johnny, the short version is the Jawn version. Exactly. The short version is the Jawn version. There you go. Destiny, you said still a good lesson. Okay. I'm glad you appreciate it. I got a little, something from it. The first bankruptcy. Anybody know the year for the first bankruptcy? Diesel D says esquires are bar attorneys. Okay, they are. First bankruptcy of America, 1871. Is that the first one? Thank you, Lisa. I don't know, but sounds good, doesn't it? Anybody have any other ideas? Lisa is saying that the first bankruptcy of America happened in 1871.
Okay. So listen, I have this book right here that you're looking at by Wendy Gonover, The Peculiar Institution and the Making of Modern Psychiatry, 1840 to 1880. I want to get into this a little bit at another time, but I'm going to read the book first. I just received the book, but I'm interested in how this intersects with the asylums. Remember? So there is something about the asylums and what they did to deny freedoms to people. As you can see, this is the asylum or penitentiary in Philadelphia called Eastern State Penitentiary. And a penitentiary goes back to penitence. So this is the Catholic Church and their rituals of penance when you show that you're sorry. And if you remember a few live streams ago, I talked about how they would have people in these penitentiaries and they would keep them isolated so they could think about what they did wrong. So this is unbelievable that this was going on 1800s and it intersects with these things, okay? Lots of creepiness. Yes, the asylum. So I'm going to read that book. Let me know if anybody has ever read that book. Hey, Amber, don't blame you, Dana. I'm sure the kids all, sorry, I'm getting into your conversation. Yes, the making of modern psychiatry. And I think it's going to be very important for us to understand how this happened, what happened to our Constitution, our original Constitution. And I will also I want to get into the laws. I want to see the intersections with the Bible. So the laws of the land. I want to read the Magna Carta. Tomorrow, if you all are filling up to it, I will read the 14th Amendment to the Constitution and the 15th. I'm interested in those particular ones right now, okay? And Tina, we are all in the crazy 1800s, the time everything began. Asylum hid the women left from reset, penitentiary for men left from reset. Those are all really like very interesting theories, like Tina. Something like it is so amazing, like what we are putting together as a gathering of minds. Thank you for adding that because those resets, the last one being 1902, but I think there was one in the 1800s as well. Has anybody pinned down any resets in the 1800s, like the late 1800s? Hey, John, if you made it out of there, you were never a functioning part of society again. I agree. Absolutely. Experimentation. Yes. Experimentation indeed. Aaron, there are many nuns and monks in the northern states. Yes. Hey, Jim, how's it going? The 14th is quite lengthy. Okay, I'll look over it and decide if tomorrow will be a fun time to do it. Let me know. What are you doing tomorrow? Like, a daytime, like maybe 5-ish. Let me know. Hey, Mickey, that would be cool with you, Mickey. You'd like to hang out and I will read the 14th Amendment. Yes. Destiny Rose. Oh my God, in Southern California, they are trying to tell the public that they, not me, will have to mask up again. How crazy is that? Okay, so that's going on, Southern California. Wow. Sean says the law of the land versus the law of the sea. Yeah, want to get into this laws. I've been inspired. I'm inspired by. Now, there's a good brother. I watch his content. His name is Kevin Gillespie. So he's got Coffee and Kush TV. Yes, Coffee and Kush. He keeps it real. I've followed his content for a while. You know how I told you, like you're meeting some of the people that I've followed their content. So Coffee and Kush is one of those content creators. And, a lot of people have gone through transitions. This period of time since 2020 has been a layer of awakening for people. So somebody last year may have had a certain position. I'm not saying this in particular to Kevin, but I'm saying all the content creators. I'm noticing like a shifting. Have you noticed that? Just a shifting where some people, they may find that it's the time now to speak a certain message. So it's according to the time that we're in. But I'll tell you right now, Mr. Kevin Gillespie, he is waking up a lot of people to the law. And a lot of us want to get our status corrected. We want to know who we are, our correct identity, and everything else that goes along with identity, land rights, and all kinds of good stuff, right? And it goes along with the Bible. As we are heirs of our Father, and I bring up repatriation. I'm very encouraged by the message that Kevin and other content creators are beginning to share, a message of forgiveness. And that applies to the genders. This war between the women and the men, the manosphere, the woman's sphere, all of this stuff. We are now having, I'm not having debates anymore about abortion. I've said it already. I will not debate another person when it comes to the subject of abortion. I feel that I have debated enough when it comes to that. It's no more debating. I know what I know about human life beginning in the womb because I go by scripture in which the Creator says, I knew you before I knit you in your mother's womb. That is enough for me. Anybody who deviates and disagrees, okay, fine. We all have to answer, but there's no more debating that anymore. We're now going to get down to some law and order because the Creator is going to turn this situation. Law and order will be restored. And that is that. So there's no more debating. Yeah, we're done with that stuff. But the forgiveness, that is a good message, a really good message. And I'm going to ponder it and pray about it. Karen is saying we are under maritime laws, which are laws of the sea, like a birth certificate, basically symbolizing we are cargo off a ship. Exactly. Yes, indeed. Locked for Life. Hello. So glad you're here with us. If I've missed saying hi to you, I want to say hi to everybody in general. So there's something that I wrote. I just wrote a few notes about this particular, let's see, yes, that's because the U.S. was now a corporation. That's right. So, Reconstruction. I want to get into decoding Reconstruction because this was all around that time. So, Juneteenth. Okay. Juneteenth, I looked at, I want to show you all something when it comes. No, you know what? I'll show you another time. Juneteenth. When you look at the push that we saw with this Juneteenth, it's a corporate backed movement. Whenever anything has a corporate backing, you already know that it's not for the people, because these corporations currently are a gang of criminals and they are breaking laws, and they're going to be held to answer for what they've been doing. This is not going unpunished. Just know this, all right? Everyone, it's not going unpunished. V-Dog, I haven't seen you in a minute. Right, Jen? There should be no debate for murder. It says in the Bible, in the law, that you shouldn't murder. There's no debate there. Anybody who needs to debate that, they need to just debate it with a wall. Go talk to the grass. I'm debated out. Anybody who doesn't get it and can't admit that that is murder, they're not the kind of person that I need in my space. In fact, all those people, they're not even around. But the thing is that I would never debate even online with anybody. This is a closed case as far as I'm concerned. So let's see. Forgiveness is the vibe right now. Okay, so I want to look into Reconstruction and unpack that. This Juneteenth issue, again, this is one of those social justice funded rebellions. And you can look at, if you go and Google Juneteenth and you look at the images, you can see how corporatized it is. It's a lot of t-shirts, fists in the air, afros, saying, this is your free, I'm free-ish. Okay, that was the tagline, free-ish. So it's again one of those things where it's just all corporatized. Looking, hello, how you doing? Thanks for joining here. Santea, oh my goodness, sis. I love you too. I missed you, Santea. Oh, this is so nice to see people coming back to the chatmosphere that I haven't seen in a while. Hey, Orthodox Southpaw, welcome. Yes. So, hey, Penny Lynn Banks, designed to separate us. That's right. And some people are not falling for it anymore. Anything, and I noticed this also in the LGBTQ communities, they are realizing and waking up to the fact that these corporations are using them and trying to push ideology that they don't agree with. Okay. I love that the community, if you want to say the gay community, that you all are standing up with us. This is not about all of this division. We never cared about who you choose to love. That was never an issue. And we know it. And many of us are uniting on the fact that we are seeing that we're all being played. I mean, all of us are being played, and it's so tacky. I was at TJ Maxx, and for Pride Month, they had all these pride things for your pets, for your dog and cat, you know, all this rainbow stuff. And it was a lot of this stuff. Nobody bought it this year, hardly. It was so much of it like after Pride. So they're discounting it. But when you look at it, I'm offended for the gay community that they, have all this stuff, and they do this to the Black community too, and it feels like pandering. It is an insult to your intelligence, and a lot of people are saying no more. We're done. We are done with the separating, but it's just terrible. Hey, Aaliyah, many veils are being lifted and more to come. That's right. That's right. Amen. Orthodox Southpaw. Wow. They're even trying to appropriate. Yeah. I couldn't believe it. It's like the dogs are now pulled into political, social issues. It's just beyond desperate. But that's not the people. And that's what we have to come together and talk about things. And you'll start to know that people are not with all of this. It's insanity, absurdity. Hey, Roger, how are you? Welcome, welcome, welcome. Thank you so much. Yes, it's insulting, isn't it? It really is. So, the Gilded Age coincided with this period of time. So we have the Civil War and all of this unrest within the states. We have these, amendments and a lot of weird stuff going on. 1865, there was a quote, "All seems well with us. All seems well with us." I'm trying to think who said that. Was that Lincoln? Maybe a quote. But I've also heard that the abortion rights people are going to try to bring back what they lost with Roe v. Wade. They're going to try to do it through this 13th Amendment. Can you imagine how they're going to try to do that? Does anybody have any idea? If I go back to the 13th Amendment, all right, how could abortion rights be included? I'm going to read it again. The 13th Amendment, Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2. Congress shall have power to enforce this article by appropriate legislation. So how would they be able to get abortion on demand through the Supreme Court using the 13th Amendment? I can't imagine, but they're going to try it, or they're already trying it. I don't know. But I just wanted to let you know that. So I will end this now so that we could get ourselves rested. You might want to do something else. Oh, I want to thank those. Thank you for your generous gifts and support. If you want to send I don't know what I am. I'm the guest teacher. I'm a student, but look, if you want to support the work, you want to support what I'm doing over here, this is how you can do it. And I thank you in advance. And thank you for the ones that have done that. So many sweet gifts and messages from you all. And I really love it. I upgrade my subscriptions to professional plans as I can. So this goes right back into the channel. So that I just, upgrade things and keep, little subscriptions going and stuff like that. Technology, things of that nature. And, whatever else, right? But I thank you. I will give you an update on the SCOBY. Remember, we're doing the SCOBY, which is due in, I think, July 21st, I believe. We have some time for the Mama SCOBY to get done. So I just, for now, want to end on the note that the 13th Amendment to the Constitution has something to do with more than what we were told. Slavery. It's so much more to unpack, and I will unpack more of it. I just wanted to read it and just show some images of that time period in the 1800s. So that would be January 31st, 1865 is when this occurred. So, again, I'll be back hanging out with you to read the 14th Amendment tomorrow. Outside, y'all. All right? And I want to thank you. Thank you for hanging out. Love you all. And thank you, Karen, for moderating. We didn't have any no trolls, right? That's great, right? We got that energy, that great love here. I love you all. Love you. And see you tomorrow.